It is certainly possible for a first-time drug offender to go to jail in Virginia. For instance, under 18.2-250 of the Virginia Code, it makes possession of a Schedule 1 or 2 drug a Class 5 felony. Well, that means it carries a maximum punishment of 10 months in jail. However, there are a variety of different reasons why that's not completely likely, depending on which jurisdiction you're in. Under 18.2-250, there is a first offender drug program where you can do what's called a deferred disposition. This is one potential outcome where your case could be ultimately continued for dismissal, and there are really two different paths that you could go with that. So the first would be if it was a felony 251 disposition, which is a disposition for first-time drug offenders. You would have to do drug treatment, probation, and then there's a significant community service component of 100 hours of community service, and of course being of good behavior, trying to maintain employment. Where if you had done all of that within the 2-year period and you didn't get in any trouble, then the case could be dismissed by the judge. If it was a misdemeanor 251, meaning that you were charged with a misdemeanor or the case was amended from a felony to a misdemeanor, then that actual deferred disposition can be done in a 1-year time frame with less community service hours of 24 hours of community service versus the 100 hours of community service for a felony drug offense. However, generally speaking, while it's possible for first-time drug offenders to go to jail in Virginia, generally you don't see that happen in many of the Northern Virginia courts.